let's understand.
Yes.
One of the things. Let's understand what circumstantial evidence is.
Okay.
Before we make some comments.
Okay.
Circumstantial evidence is not direct evidence. And the courts have also often, all the time, said that proof beyond reasonable doubt is not proof beyond all doubt.
Yeah.
That point has been made.
Okay.
And the standard, my brother Paul wants to take the judiciary, then nobody will ever be convicted in this country. So what is circumstantial evidence? The courts of appeal explained circumstantial evidence, and the judge, essentially reproduced it in Bediako versus the Republic. And this is what it's important that your viewers hear this.
Okay.
Circumstantial evidence that's Bediako versus the Republic,
okay.
And that's 1987, 1988. Circumstantial evidence was evidence of surrounding circumstances which by undesigned coincidence was capable of proving a proposition with the accuracy of mathematics. This is a criminal trial, and yet this is the standard. In criminal cases, it was sometimes not possible to prove the crime charged by direct or positive evidence of persons present at the time the crime was committed. So where the testimony of, there's the Court of Appeal speaking,
yes,
where the testimony of eyewitnesses was not available, the jury was entitled and indeed permitted to infer from those facts, from those facts which the prosecution had proved. Other facts necessary either to complete the elements of guilt or establish innocence. However, before drawing the inference of the guilt of an accused from circumstantial evidence, it was important to make sure that there was no other coexisting circumstance, it's not your words, circumstance, which would destroy or weaken the inference. Let me just apply it here. So, as you rightly said, it is not for nothing that when there is an arrest of or accused person of 4 or 3, usually, I'm not saying it may not be good, but usually they are all supposed to be coached together. But because the moment anyone says anything against the other or any of you, it goes to hurt all of you. Because if you were all found in a room and yet you are all saying different things as to the reason you were in the room, then it presupposes that all of you know something that we all don't know. Do you understand? So if the court is saying that we must be sure, or the court must be sure that the inference, there is no coexisting circumstance that could weaken the inference. We were not there. You and I were not there. You actually said you know the gentleman. The gentleman was there on your authority. You said, yes, it's true. He was there on my authority. The essence of a circumstantial evidence is to find out whether what you are saying actually could or would be the truth as compared to what another person is saying. So you make certain inferences. So whatever happened, the judge admitted that because there was no, and you see, proof evidence is not just paper. It could be calling a witness. That in all this, I even had a meeting with him here, and we said this. Muntumi did not produce a single person who knew about whatever arrangement they had. The fact that they didn't exist does not mean that actually nothing happened, because it had been. And again, let me.
The other part the other guy didn't produce any other person.
No, they were. The gentleman was arrested for an offense. Let's get it. He wasn't just a witness. Please, that's the difference. The gentleman was arrested, and he said, "I am here because of this person." That is a way. There is some weight that we put. It's not just anybody. Then he was arrested during the act, and he said, "I'm here," and you are saying, "Yes, I know him. I took him there." The only departure is what you claim you made. So the judge will evaluate whatever you are putting across, whether it's actually the case. That's where circumstantial evidence comes in, because none of you is able to, because the only contention is what he may have done there. That's the galamsey, which is the fact that it was done. There is no dispute. Who did it? And it's also known that the gentleman.
He also mentions that reclamation was also done.
No, but the reclamation that is done, the judge said, even if that is the case, you didn't even have the permission the law to do it. But the judge smartly came to the offenses that is before him. So nobody was, and again, let me put it, nobody was convicted. I've heard some grounds of appeal. If you take I can confidently say, if your grounds of appeal is under the law of reclamation, you lose, because nobody was convicted under that crime.
Okay.
The crime is on illegal mining and facilitating. Now let me read, because he said something about the facilitating. I don't know which article he's reading, and unfortunately the gentleman has not quoted the decision for me. I will deal with the decision where the court dealt with the facilitation, when the court was concluded all his findings on the counts. That's on count 4, purposely facilitating an unlicensed mining. The court never said ought to know. I don't know where he got it from. Let me read to you. This court has found
to know that he was doing galaxy.
Where did the court say it? That's the question I'm asking. I have the judgment here, and the judgment per 56. So please, let's go with the judgment. On count 4, purposely facilitating an unlicensed mining. That's what you refer to. Let's listen to what the court said. This court has found that PW2's mining and reclamation activities on the concession contravened. He didn't say you ought to know. Contravened 14(1) and section 59 of Act 703. That no penalty is separately specified in the Act for a contravention of section 59. That first accused facilitated PW1 and PW2's contravention by permitting them onto the site, introducing PW2 as a supplier of excavators. And that was also made. Wontumi admitted that yes, he introduced him to him, but he said he never paid a dime. He considered a lot. You introduce somebody for do we use excavators to plant coconut? Advocates in this country, even reclamation, bulldozers are used, not excavators. You are not saying
so that even if they didn't mine and it was only reclamation day.
No, but that's a fact.
Hold on. From what you are reading, it looks like even if they didn't mine, it's still an offense to take him there without the minister's permission.
That has been made.
No, I'm saying something.
No,
even if they didn't
the assumption that it looks like I'm reading. So from what you are reading. No, I'm not done. Please. Introducing PW2. Okay, so let me read it well for you. Maybe you didn't get. This court has found that PW2's mining and reclamation activities on the concession, because both were found.
Yes.
On the concession contravened section 14(1).
That's what I'm saying. So reclamation contravenes.
Yes.
Mining also contravenes.
Yeah, no, but different laws.
Yeah, I get that.
Yes.
But the reclamation contravenes.
Yes.
So that even if there is no mining,
why are you saying no mining?
No, you don't seem to get it.
I get it, but the offense, no.
It must be together.
No, it necessarily not. But I'm saying that.
So one can be prosecuted for taking somebody onto your land without the minister's license. Whether it's for reclamation or whether it's for mining. If I let you on my land without the minister's license, the offense has been created.
Yes, different offenses. Well, because you see that
an offense has been created.
Yes.
If I say go onto my land, I don't have the minister's permission to take you on my land.
If it's a concession,
but I say go and reclaim land.
Yes,
that's still an offense. It's still an offense.
But that
the offense is grounded because it was without the minister's permission.
Absolutely.
Okay.
Yes. So, but in this case, because in that case, they have the position of Wuntumi's lawyer is that the offense is defined, but no punishment attached with the reclamation. Yeah. So the judge did, and I'm saying that the judge didn't convict on reclamation.
But was that correct law?
What?
That the reclamation has no offense attached to it?
It is not, but the judge dealt with it.
And the judge said it's bad law?
No, the judge didn't. He gave and he did some justice to it. We don't have time. I'll show you where he said that. But you see, for me, the fact that nobody was convicted on reclamation is the point I'm making. But let me even finish reading what the judge said.
Time is almost
I beg. Introducing PW, he gave me 2 minutes of time. Introducing PW22, a supply of excavators, and enlisting the Western Regional Security Council to protect PW2's operations. In fact, that's what happened. Because the gentleman said that Wontumi actually applied and got permission from the Western Regional Security Council to protect him, to reclaim. I mean, that's where circumstantial evidence comes in. The judge ought to analyze, really, did you need the Western Regional Security Council's protection to reclaim a land?
Okay.
So obviously, you are not telling the truth. And that is what the Juya versus Admire, all the circumstantial evidence points to. Okay. Anybody that comes to court and says, I'm not guilty, certainly, even if he did it, he will lie.
All right.
I'm not saying this is what happened. Okay. So it is for the judge to evaluate what you have put there and put the probative value on the pieces of evidence. How do you go to court and say, I know him, I took him there, but what he was doing, I didn't, and you didn't show